Yes, Mr. Cox, we're still with Salah, are we?
Please. My Lord, the Court set out, before reaching the fourth question, the Court set out its established case law on determining the personal scope of the specific anti-discrimination provisions which it had been asked to address. And then we see at paragraph 45, in the middle of page 2722, its conclusion on those issues. Since the order for reference does not provide sufficient information to enable the Court to take account of all the circumstances which may be relevant in this case, it is for the referring court to determine whether a person such as the appellant in the main proceedings comes within the scope ratione personae of Article 48 of the Treaty and of Regulation number 1612/68 or of Regulation number 1408/71. So pausing there, the Court was saying that if the appellant fell within the personal scope of those provisions, then the Court could deal with the issue of discrimination under those provisions. The fourth question only arises if the appellant wasn't within the personal scope of those provisions, and the Court therefore looks at it on a different basis, and as we shall see, under Article 6 of the Treaty, which is now Article 12, that is the general prohibition on discrimination. And I simply want to show that to your Lordships briefly to see how the issue of direct discrimination arose, not the text of the treaty, but these provisions. So you see paragraph 46, by its fourth question, the referring court seeks to ascertain whether community law precludes a member state from requiring nationals of other member states to produce a formal residence permit in order to receive a child-raising allowance. And then we see the conclusion on that, or the provisional conclusion, as it were, on that first issue at paragraph 54. Consequently, for a member state to require a national of another member state who wishes to receive a benefit, such as the allowance in question, to produce a document which is constitutive of the right to the benefit and which is issued by its own authorities, when its own nationals are not required to produce any document of that kind, amounts to unequal treatment. So again, pausing there, even though in some respects this condition, well, we shall see, in some respects this condition could be described as one which clearly foreigners could meet, they simply needed to produce the document. It was an additional hurdle that only they were subject to. The Court continues, in the sphere of application of the treaty, and in the absence of any justification, such unequal treatment constitutes discrimination prohibited by Article 6 of the EC Treaty. So it may be suggested that that reference to justification implies that such direct discrimination can be justified. And that's why I take you to this case in that sense, because it is tentatively against me, but we shall see how strongly it is. Just want to show your Lordships how the conclusion is reached. Paragraph 56. At the hearing, the German government, while accepting that the condition imposed by the German law constituted unequal treatment within the meaning of Article 6, argued that the facts of the case being considered in the main proceedings did not fall within either the scope ratione materiae or the scope ratione personae of the treaty, so that the appellant in the main proceedings could not rely on Article 6. The Court deals with those matters then. Paragraph 57, first of all, the scope ratione materiae, that reference should be made to the replies given to the first, second and third questions, according to which the child-raising allowance in question indisputably falls within the scope ratione materiae of community law. So because the child-raising allowance fell within Regulation 1612/68 and Regulation 1408/71, therefore it fell within the material scope. Paragraph 58, as regards its scope ratione personae, if the referring court were to conclude that in view of the criteria provided in reply to the first preliminary question, the appellant in the proceedings before it has the status of worker within the meaning of Article 48 of the Treaty and of Regulation 1612/68, or of employed person within the meaning of Regulation number 1408/71, the unequal treatment in question would be incompatible with Articles 48 and 51 of the Treaty. So the Court again is reminding the National Court that it only needs to look at Article 6 if the person concerned falls outside the personal scope of those more specific prohibitions on discrimination. And I'll take your Lordships to the case law that spells that out in more concrete terms in a moment. The Court then looks at whether, if that should not be the case, the opening words of 59, there is nevertheless a prohibition on discrimination upon which the appellant can rely. We see at paragraph 61 at the bottom of the page, as a national of a member state lawfully residing in the territory of another member state, the appellant in the main proceedings comes within the scope ratione personae of the provisions of the Treaty on European Citizenship. And then Article 8.2 of the Treaty attaches to the status of citizen of the Union the rights and duties laid down by the Treaty, including the right laid down in Article 6 of the treaty not to suffer discrimination on grounds of nationality within the scope of application ratione materiae of the treaty. It follows that a citizen of the European Union, such as the appellant in the main proceedings, lawfully resident in the territory of the host member state, can rely on Article 6 in all situations which fall within the scope ratione materiae of community law, including the situation where that member state delays or refuses to grant to that claimant a benefit that is provided to all persons lawfully resident in the territory, on the ground that the claimant is not in possession of a document which nationals of that same state are not required to have. And then the passage that might be against me, 64, since the unequal treatment in question thus comes within the scope of the treaty, it cannot be considered to be justified. It is discrimination directly based on the appellant's nationality, and in any event, nothing to justify such unequal treatment has been put before the court.
That's the subject of a footnote, isn't it?
Indeed. Well, the court appears to be having it both ways, which is it can't be justified, but in any event, even if it could be, it hasn't been attempted to be.
Well, she reads that just as an afterthought and brushes it aside, really.
Well,
is that what you're asking us to do?
I want to take your lordships to a much more recent case, the case of Wood, some 10 years later, where I say the court has ruled that out, albeit in brief terms.
Yeah.
And the judgment in Wood is at volume 7, at tab 81. And the judgment begins at paragraph 276 of the report. And you can see from paragraph 1, the reference for preliminary ruling concerns the interpretation of the first paragraph of Article 12, so the treaty prohibition on discrimination. The reference was made in the course of proceedings brought by Mr. Wood, a British national, against what appears to be the French equivalent of the Criminal Injuries Compensation Board, concerning the latter's refusal to grant him compensation on the grounds of his nationality to make good damage caused by a crime committed outside French territory. We see that the relevant French rules provide in paragraph 2, but if your lordships look over to the next page, down to the number 3, inside the French text, or the text of the French law, the person injured is a French national, and this is a condition, or if this is not the case, the acts were committed on the national territory and the person injured is either a citizen of one of the member states or subject to an international treaty or agreement. And sorry, if your lordships would just look back to the opening words of that French provision towards the bottom of page 276, we see that those are cumulative conditions. Now, what had happened, we can see from paragraph 3, is that Mr. Wood's daughter had been killed in a road traffic accident in Australia. And therefore the crime had not been committed on the national territory. And since Mr. Wood was not a French national, he did not qualify for the compensation payment under French law. Now we see in paragraph 7 that Mr. Wood had been living, working and paying taxes in France for 20 years with his partner, a French national. And we can see also that from paragraphs 4 and 5 that the compensation was paid to the late Miss Wood's mother and her siblings. So it's only Mr. Wood, the father, who didn't get the payment because he was the only one who wasn't French. Then the court's consideration is quite short. We see in paragraph 11, in the main proceedings according to the order for reference, Mr. Wood, a British national, has exercised his right of freedom of movement for workers within the meaning of Article 39, or freedom of establishment within the meaning of Article 43 by living and working in France for more than 20 years. Therefore, Mr. Wood's situation falls within the scope of application of the treaty, and he may rely on his right not to suffer discrimination by reason of his nationality. It is in this regard settled case law that the principle of non-discrimination requires that comparable situations must not be treated differently and that different situations must not be treated in the same way. Such treatment may be justified only if it is based on objective considerations independent of the nationality of the persons concerned and is proportionate. And then we see a recitation of the facts in paragraph 14, and at paragraph 15, thus this difference in treatment based expressly and solely on the nationality of Mr. Wood constitutes direct discrimination the French government itself admits that in a case such as this, there are no reasons capable of justifying such difference in treatment. Now, we say that a case such as this means a case of direct discrimination, not a case with the same facts as that of Mr. Wood. And we say that the term no reasons capable of justifying such difference does not mean that, as it happens, no reasons exist. It means that no reasons can ever exist that could justify that sort of rule. And your lordships will see that the ruling of the court, while the court had been asked about Article 12, the court actually simply says community law precludes legislation of a member state of that kind. No doubt because it didn't want to exclude the possibility that Mr. Wood could have relied upon Articles 39 and 43 as well.
Yes.
Now we say that while the language of the cases isn't as clear as it might be, that it is clear when one reads the entirety of the test.
Sorry, do we get, we see justification is dealt with by Advocate General. She seems to have thought there was, or she, there was no just 40, 41, 42. They said there was no justification. It doesn't say that it wasn't in principle.
Well, in my submission, if we just turn to her reasoning, paragraph, sorry.
Where are we going?
It's page, if you could just turn to
273.
It's
page
questionable
273.
whether it can ever be justified.
Where Advocate General Crocott deals with this question, so under the heading justification, page 273, whether that discrimination is justifiable. A difference in, now she records and it's common ground that this is the test across the board and here.
Yeah.
A difference in treatment can be justified only if it's based on objective considerations independent of nationality.
Yeah.
She then says it is questionable whether a national rule that discriminates directly on grounds of nationality can ever be justified.
Well,
However, there is no need to discuss this here, since even if one assumes that it may be possible, it must be concluded in the present case no such justification exists. Well, my submission is that it is that, first of all, that the court hasn't adopted that limited reasoning, and it doesn't express itself in the way that the court did in Martinez-Sala. What the court is saying in my submission at paragraph 15 is that direct discrimination is incapable of justification. And in my submission that logically must be so, because the court affirms that the only justification that is permissible is one that is independent of nationality. Now, if one has a rule that discriminates based upon nationality, it cannot be independent of nationality. It is logically impossible. Considerations independent of nationality can only justify a rule which operates independently of nationality, but because of the facts of the persons affected, tends to, or does statistically, as it were, discriminate in favour of one group and against another group. So a rule like the one that we saw earlier, where the payments were reduced if one lived outside Germany, is simply is a rule that is independent of nationality. There is no bar on Germans living outside Germany. There is no bar on non-Germans living inside Germany. But the court holds that it's indirect discrimination because it is capable of producing the same result. Because, as a rule, Germans tend to live in Germany and non-Germans tend to live outside Germany. But a rule that says French nationals can get the award if it happens outside French territory, but other persons can't, is not a rule that is capable of being justified by considerations independent of nationality, since to justify it, one would need to base the rule upon the distinction between French nationals and other persons, which is a distinction of nationality.
It's interesting to compare what is said in the second sentence. Said it must be concluded that in the present case no such justification exists, with paragraph 15 in the court's judgment. And you say no reasons capable in a case such as this is a general statement, whereas she is much more particular in what she says. Is it a she?
It is she, yes.
Yes.
My lord, that's true. I make the submission that I do because in my submission it is incapable to... we do not conceive, and we see no case in which the court has conceived, and we'd say logically it is impossible to conceive of considerations independent of nationality that are the basis for a rule that discriminates based upon nationality. I would like, however, to advance a possible explanation for the problem as to why the court hasn't spelt this out, and that is that there are a number of exceptions to rules on discrimination, and that it may be that what is happening here is that the court has in mind, or that the Advocate Generals have in mind, the possibility that there will be an exception to the rule on discrimination, different from justification, and I accept that that isn't what's being spelt out, but I would just like to take the court to a couple of rules that show that the prohibition on discrimination is not universal, and in particular Article 39 of the treaty, which appears in Volume 1 of the Authorities.
And did you say this point is acte claire?
I say it is acte claire, yes, because I say that the court's case law, that justification must be independent of considerations of nationality, is acte claire, and that logically it follows from that that direct discrimination cannot be justified. But if I could just ask your Lordships to look back at Article 39 of the treaty, which is at Divider 10 of the first volume of Authorities. And there are two limitations here on the prohibition on discrimination. We see the prohibition itself stated in general terms in paragraph, I'm so sorry, we should turn to page 57 for Article 39.
Yes.
And at paragraph 2 of the article, such freedom of movement shall entail the abolition of any discrimination based on nationality between workers of the member states as regards employment, remuneration and other conditions of work and employment. And then we see two limitations. In paragraph 3, we see the limitation, it shall entail the right subject to limitations justified on grounds of public policy, public security or public health. Now, as I've mentioned in the case, and I can take your Lordship to the cases on it if needs be, it's that limitation that permits member states to remove from the territory a worker in a situation where they could not remove their own nationals. And we see also in
Sorry, which is B?
No, the opening words in 3, subject to limitations justified on grounds of public policy, public security or public health. So that's where a German national, for example, poses a threat to the security of the United Kingdom. He may be removed even though he is a worker. And even though that would constitute discrimination vis-à-vis a British citizen who could not be expelled from the United Kingdom. And it's that limitation permits discrimination on grounds of nationality. I've mentioned the cases. I'm happy to take the court to the cases on that point. They're mentioned in my printed case at paragraph 82.
82?
82. But I can take your Lordship's to it. A recent case is Pereira Rock, which is in the Authorities at volume 3. Volume 4, at tab 48. No, I'm sorry. If your Lordships could bear with me, I'm sorry, I'm reading off the case, and I'm sorry, that is a mistake. It's volume 7, tab 75.
Seven what?
775, I think.
Volume 7, tab 75. And your Lordships can see from the head note it concerned the deportation of a Portuguese national from Jersey on the grounds of a series of convictions for theft. Now, the case concerned the application of EU law to Jersey, But the particular point I want to go to it for is at paragraph 37, which is at page 178. And that's right at the bottom of page 178 from the court's judgment. And we see, in order to assess the implications of the principle of equal treatment laid down by Article 4 of Protocol number 3. Now, pausing there, that's the specific provision that applied to Jersey. It is important to recall in the first place that the court has held that the reservation contained in Article 48.3, the treaty, that's what is now 39.3, permits member states to adopt with respect to the nationals of other member states, and on the grounds specified in that provision, in particular grounds justified by the requirements of public policy, measures which they cannot apply to their own nationals, inasmuch as they have no authority to expel the latter from the national territory or deny them access thereto. And we see at 38, that difference of treatment between a state's own nationals and those of other states derives from a principle of international law which precludes a state from denying its own nationals the right to enter its territory and reside there, and which the EC Treaty cannot be assumed to disregard in the context of relations between member states. And that is therefore, that is not properly called a justification for discrimination, it is an exception to the prohibition on discrimination. And if your lordships still have open the text of treaty provisions, Divider 10, Volume 1, just to continue on Article 39.
When you say it's exception rather than a justification, does proportionality apply?
Yes, proportionality does apply.
I thought it did.
So the scope of the exception is limited, and the case law of the court is that a derogation must be strictly construed, and that the application of a derogation, or the use of a derogation, must be proportionate to the aim pursued. But in my submission, it is in principle different from the possibility of justifying a measure which is indirectly discriminatory, because it is directly discriminatory. So the same overarching principles apply, but it is not properly labelled justification. And it requires the identification of a particular provision of the treaty or a particular provision of subordinate legislation which expressly permits the departure from the normal rule. And what we are dealing with here is a case where the Secretary of State doesn't identify any exception to the normal rule set out in the treaty or in the legislation. He purports to accept that he must show considerations independent of nationality, but in fact advances an argument that is based upon considerations of nationality. What he really needs is an exception, but he doesn't have one, which is why he has to advance it under cover of the justification argument. The other exception, another exception, is in Article 39.4. The provisions of this article shall not apply to employment in the public service. And as we can see, and we may need to see later on the Irish point, that derogation is one of the provisions that the Court of Justice has construed narrowly, but it's still there. So that is another exception. And I showed your lordships earlier the exception in Article 3.2 of the regulation about elections to social security bodies. So where the authors of the treaty or the authors of subordinate legislation want to make an exception to a prohibition on discrimination, they must do so expressly, and they have done expressly. But in my submission, where a matter falls within the personal and material scope of the prohibition on discrimination, if that measure is directly discriminatory, that is based on nationality, it cannot be justified. Can I just, before I finish on the point about direct discrimination, can I just ask your lordships to look at James and Eastleigh Borough Council, which was mentioned before lunch. It's in volume 2 of the authorities at tab 32. we see the facts from the head note. Mr. James, who had retired, and his wife, both of whom were 61 years of age, went to a leisure centre run by the council. The wife was admitted free of charge, but the plaintiff had to pay an admission fee as the council only provided free admittance to people who'd reached state pension age, which in the case of a man was 65 and in that of a woman was 60. If I could ask your lordships just to look on the particular point that I want at the speech of Lord Ackner, which is at page 769.
If they had in fact said free for anybody who had retired from work, would that have been all right?
Yes, it might have been, yes, because that wouldn't, would not have been direct discrimination, no. Because it didn't embody or have wrapped up in it a legal criteria that expressly distinguished on grounds of sex. So you see at 769 at E, the essential question raised by this appeal is whether this less favourable treatment received by Mr. James was, to quote the important words of section 11A of the Sex Discrimination Act, on the ground of his sex and therefore unlawful. The answer in my respectful submission is clearly in the affirmative. It was common ground in the courts below, and indeed it was so accepted by Mr. Beloff before your lordships, that the council's policy was discriminatory. The council was applying a gender determinative formula for entitlement to free swimming. You had to be a person who had reached pensionable age, 60 for women and 65 for men. Such a formula was inherently discriminatory. In the County Court, no evidence was given as to why the council had decided on this policy. This omission was, in my view, fully justified because such evidence would have been irrelevant. The policy itself was crystal clear. If you were a male, you had vis-à-vis a female a 5-year handicap. You had to achieve the age of 65 before you were allowed to swim free of payment, but if you were a female, you qualified for free swimming 5 years earlier. And my submission, that's a direct analogy with a requirement to reside. British citizens and Irish citizens have a right to reside because they are British or Irish. They get it anyway. Other citizens of the European Union need to do more to get it. They need to have worked here or to be self-sufficient here or to be the family member of such a person here. Now, of course, it doesn't, just because it's inherently and directly discriminatory, didn't require that no men could qualify under it, nor that all women could qualify under it. It only required that one sex be given an express advantage based upon their sex. And that, in my submission, is the same position here. Can I then just turn to...
I mean, in our case, the Court of Appeal said, I mean, the justification for all this is, let me just remind myself of the phrase.
Well, there is the justification in the Statement of Facts and Issues.
Yeah.
At page 11, paragraph 33.
All right. There's something about integration. Yeah, here we are. Social and legal. Well, no, that's different. That's ours.
Can I just show your lordships what it says in the Statement of Facts and Issues, and I'll take your lordships to the Court of Appeal in just a second, if I may.
This is the resources point, is it?
Well, paragraph 33 is that it's to protect the resources of the United Kingdom by refusing means-tested benefits to non-economic European Union migrants. Not to migrants, but only European Union migrants. In other words, those who are not British or Irish. And that this is based upon an asserted principle of EU law that member states are entitled not to grant social assistance to non-economically active nationals of other EU member states. Now, in my submission, that's a discrimination. That is a justification that is based solidly on nationality. The Secretary of State's desire is not to protect the budget from British citizens who've just arrived, or British citizens who are non-economically active, or even Irish citizens who are non-economically active. He's only interested in protecting the budget from citizens of other EU member states.
Yes. Now, what I was looking for was economically or socially integrated. That's a concept which you find throughout the Court of Appeal judgment, and I think throughout the respondent's written argument.
My Lord, yes.
Now, all I'm really wondering, following from James and Eastleigh, is whether if they had said, I don't know how you would crystallised and incorporated in coherent terms. But if they'd said, you don't get this if you're not economically or socially integrated into the UK, would that have been all right?
Yes. And in fact, I can show your lordships how such a test can operate in the Court of Justice's judgment in Collins. That's in volume 4 at tab 50. And this will take your lordships to the caveats that community law would enter as to that requirement, but in principle, such a requirement is not directly discriminatory, and it may be indirectly discriminatory, but it may be capable of justification. Now, Mr. Collins was an Irish citizen who came to the United Kingdom from either Africa or the United States. So he didn't come from Ireland. And he was refused a job seeker's allowance on the grounds that he was not, in fact, habitually resident in the United Kingdom. Now, the material time was before the introduction of the right to reside test, but of course he would have passed the right to reside test because he's an Irish citizen. But what the court was concerned with was the compatibility of a requirement to be habitually resident in the United Kingdom. And deal with that at page 180, paragraph 65. After the court had set out its traditional holdings on equal opportunities and equal treatment, paragraph 65, the 1996 regulations introduce a difference in treatment according to whether the person involved is habitually resident in the United Kingdom. Since that requirement is capable of being met more easily by the state's own nationals, the 1996 regulations place at a disadvantage member state nationals who have exercised their right of movement in order to seek employment in the territory of another member state. Now, pausing there, of course, there's a crucial difference between the requirement to be habitually resident and the requirement to have a right to reside, because a British citizen doesn't get a head start or an advantage in the habitual residence test by being British, let alone pass it simply by being British, whereas the right to reside test is passed simply by being British. And we then see in paragraph 66, a residence requirement of that kind can be justified only if it is based on objective considerations that are independent of the nationality of the persons concerned and proportionate. And then the court has already held that it is legitimate for the national legislature to wish to ensure that there is a genuine link between an applicant for an allowance in the nature of a social advantage within the meaning of Article 7.2, Regulation 1612/68, and the geographic employment market in question. And I would accept that that sort of reasoning is equally applicable to the benefits listed in 1408/71 in general terms. And then we see 69, it may be regarded as legitimate for a member state to grant such an allowance only after it has been possible to establish that a genuine link exists between the person seeking work and the employment market of that state. 71, the United Kingdom is thus able to require a connection between persons who claim entitlement to such an allowance and its employment market. And then we see in 72, however, while a residence requirement is in principle appropriate for the purpose of ensuring such a connection, if it is to be proportionate, it cannot go beyond what is necessary in order to obtain that objective. More specifically, its application by the national authorities must rest on clear criteria known in advance, and provision must be made for the possibility of a means of redress of a judicial nature. In any event, if compliance with the requirement demands a period of residence, the period must not exceed what is necessary in order for the national authorities to be able to satisfy themselves that the person concerned is genuinely seeking work in the employment market of the host member state. Now, I accept that obviously the expression is different because it's concerned with a different benefit and a different test. But it's not disputed that an habitual residence requirement can be justified, in principle, as a condition of entitlement to a benefit like state pension credit. Now, in this case, the appellant has been accepted and found to meet that requirement. The distinction, as I say, is that this condition is not dependent on it's not based upon nationality. It is independent of the nationality of the persons concerned. It may produce the factual outcome of discrimination, that's what the court is saying at 65, And therefore it needs to be justified by objective considerations independent of nationality, and the objective consideration is a genuine link with the employment market of the member state. But of course that rule, as I say, could be failed by both British and Irish citizens. It was failed by Mr. Collins, and it has been failed by British citizens in other cases. This rule can't be. So at the policy level, there's nothing to stop the Secretary of State from introducing requirements to show economic or social integration in the United Kingdom, so long as those requirements are proportionate and applicable independent of the nationality of the persons concerned. Can I just then turn to some of the matters that the Court of Appeal below raised as justifying the answer that they produced? The first point is whether or not Article 12 of the European Community Treaty has the effect of cutting down the application of Article 3 in the case of persons who fall outside the scope of Article 12.
Could you give a cross-reference to the paragraph in the Court of Appeal?
Yes, certainly. The conclusion of the Court is at paragraph 52 of their judgment, which is at page 19. I could just take your lordships there, though it may need some unpacking.
I mean, just trying, again, looking at
Yes, of
it
course.
in the round, the general shape of it. I mean, as I understand it, the Court of Appeal say, well, if you failed Article 12, by the same process of reasoning, you fail Article 3,
Exactly.
this other regulation. Your case, or certainly, as I understand it, the Ayres case is, actually, you shouldn't have failed Article 12, and therefore you certainly shouldn't fail Article 3 either.
Well, that's Ayres' case. That's not my case. I put my case on a more limited basis. First of all, the Court didn't say by the same process of reasoning, because it couldn't do. The reason that we would have failed under Article 12 is that we fall outside, well, on the British Court's reading of Troiani, is that we fall outside Article 12's personal scope. So that's why we would have failed under Article 12. Now, that option isn't open to the Secretary of State because he accepts that we fall within the personal scope of Article 3. So what the Court in effect, the Court of Appeal in effect did was said, well, because you fall outside the personal scope of Article 12, therefore that itself must be some sort of a justification for discriminating against you within the personal and material scope of Article 3 of 140871. And we say that's wholly impermissible. It confuses two quite different things. As we shall see, the Court of Justice wasn't saying in Troiani that it was justified to deny social assistance to persons who fall outside the personal scope of Article 12. All it was saying was if you fall outside the personal scope of Article 12, then discrimination in that regard isn't prohibited as regards you. It's a question of justification.
Is it the penultimate sentence of paragraph 52? I'm trying to find out where the particular point is.
It is indeed the penultimate sentence of paragraph 52, yes.
And that,
So what the Court did was it said that because Article 3 was derived from Article 12, therefore, in essence, it couldn't provide any greater benefit than Article 12, even though the Court was recognising that the personal scope of Article 3 was wider than that of Article 12. Now, in my submission, the Court, now that wasn't, I think it's fair to say that wasn't the basis of the cases that have been put to the Court of Appeal. I just want to take your lordship's two cases that would have been cited to them to show that that's the wrong approach. And what I want to show your lordships is that the constant approach of the Court of Justice has been that Article 12 is a fallback. One only looks at Article 12 where there isn't a specific prohibition on discrimination in play.
So, I mean, you're accepting, are you, that in those other cases, Abderrahman and Kazmarek, that it did fall outside the personal scope of Article 12, are you?
My argument is premised on the basis that the personal scope of Article 12 is limited to persons who have a right to reside in the territory of the member state. Either under EC law or under national law. That is the way that Trajani was read by the Court of Appeal in Abdirahman, which I understand permission to appeal was refused in. And, sorry? And in Kashmir. Well, and in Kashmir. Oh, Abdirahman permission wasn't sought, is that? Right. Oh, I didn't realise that, I'm so sorry. That's was the basis upon which the Court of Appeal proceeded in Abdirahman, or held in Abdirahman, and as I'm told by my learned friends, the Supreme Court refused permission to appeal in Kachmarek, where the court held itself bound by Abdirahman to apply the same approach. Now, obviously my learned friend Mr. Drabble, Mr. Banner, argue in their case, or suggest in their case, that might have been inappropriate and that Article 12 might apply to persons who are lawfully present, such as the appellant, even though they lack an enforceable right to reside. But I don't need to go that far. I don't want to go that far, because that raises another hurdle for me to get over. I don't need to go that far, because it's accepted that the appellant falls within the personal scope of Article 3. And because I can show your lordships judgments that make it acte claire that Article 12 doesn't limit the scope of subordinate legislation prohibitions on discrimination. So, in my submission, your lordships can resolve the case in the favour of the appellant simply by applying the settled case law on Article 3 of 140871 and without reaching the wider question of the personal scope of Article 12. Can I just take your lordships then to the first of those cases, which is Mora Romero, which is in volume 7 at tab 73. Now, we can see the facts at the beginning of the report in the headnote, just below the indented paragraph. Mr. Romero was a Spanish national residing in Spain whose father, who had been employed in Germany, had died following an accident at work in 1969. From the commencement of his education and vocational training, he had received orphans' benefit from the German Social Security institution. For the period of his Spanish military service, payment of the benefit had been suspended. On the subsequent resumption of his training, the benefit was again paid until 1st of March 1990, as he had reached the age of 25. Mr. Mora Romero requested that the orphan's benefit be paid to him beyond the age of 25 for a period equivalent to that of his military service in Spain. Now, the courts, the domestic courts, questions are at 1145 at paragraph 8. Or question, the court asked an omnibus question. Are Articles 6, 48 and 51, which of course are now Articles 12, 39 and 42, and Article 7 of Council Regulation 1612-68 on freedom of movement for workers within the community to be interpreted as permitting the legislature of a member state to extend the period for drawing orphans' benefit beyond the age of 25, only in respect to those persons whose education and training has been prolonged before the age of 25 through fulfilment of the duty of military service in accordance with the laws of that state. So we can see that if Mr. Mora Romero's military service had been in Germany, he'd have gone on getting the orphans' payment for the equivalent period of his military service. Now, the court's judgment begins at 1155. And the court looks first at whether it should consider the matter under Article 6. It does that at paragraph 10 on the next page at the bottom. And the court says it's settled case law that Article 6, which lays down the general principle of the prohibition of discrimination on grounds of nationality, applies independently only to situations governed by community law, in respect of which the treaty lays down no specific prohibition of discrimination. In the matter of freedom of movement for workers, the principle of discrimination has been given effect and specific expression by Articles 48 to 51, by acts of the community institutions adopted on the basis of those articles, and in particular by Regulation 1612/68 and Council Regulation 1408/71, the provision upon which I rely. And then 12, consequently, if a case such as that in point in the main proceedings falls within the scope of those articles of the treaty and of the community regulations adopted on the basis of them, it is unnecessary to give a ruling on the interpretation of Article 6. And that is the approach that the court has adopted in every other case that we have been able to find. Certainly no contrary case was cited below, nor in the respondent's submissions. So the court simply doesn't consider the scope of Article 12 in a case which falls within a different provision. And the court goes on to hold, as we can see over the page of paragraph 20, that Mr. Romero's situation did not come within 1612 of 68. He was not a dependent of a worker, because his father, we can see from the top of the page, his father had died before Spain joined the community. But we can see that the court held that 1408/71 does apply because his father had paid into the insurance scheme of Germany, and at paragraph 22, he was a survivor. Paragraph 23, it follows that a person in circumstances such as those described by the National Court is one of the persons covered by Regulation 1408/71. And the court goes on to hold that the rule in question is one that is prohibited discrimination. We see that in paragraph we see that in the concluding holding. That state is required to assimilate military service in another member state to military service under its own legislation.
What have you just read?
I'm so sorry, the
Oh,
holding...
this is the very end of 36.
Very end, yes.
Yes.
So the court didn't ask whether or not Mr. Moro Romero fell within the personal scope of Article 6, as it then was, Article 12 as it now is, nor did it ask whether or not the benefit in question fell within the material scope, because it wasn't concerned with those issues. So it follows in my submission that one does not read Article 3 down to fit within Article 12, and that each of the subordinate provisions applies independently. Now, can I just take your lordships then to Abdirahman to show your lordships what I say the ratio of those judgments is, and why the appellant doesn't need to challenge them in these proceedings. So, volume 2 of the authorities, divider 29. And this is a judgment of the Court of Appeal. Now, the first point at issue in the appeal was whether or not the appellants had a right to reside. And we can see this in the headnote. Under the holdings in the headnote, point 1, that there was a distinction in United Kingdom law between a right to reside and lawful presence. That although a European Economic Area national who was a qualified person within the meaning of Regulation 5.1, the Immigration European Economic Area Regulations 2000, had a right to reside, turning over the page, such a right did not extend to a European Economic Area national who was not a qualified person. That was the holding on the first issue. Now, if I could just take your lordships to the reasoning on the second issue, which is at page 270. And we see there under the rubric Article 12 EC of the EC Treaty, discrimination. The next question is whether such a conclusion is in breach of the prohibition in Article 12 of the EC Treaty on discrimination on grounds of nationality. So the conclusion there being that Mr. Abdirahman and the other claimants had no right to reside and were therefore not entitled to benefit under national law. 42, two questions have to be considered. Is the right claimed one which is within the scope of application of the treaty? And if so, is the discrimination objectively justified? The Commissioners held that it was within the scope of the treaty, though without addressing the point in their reasonings, but that it was justified. The Secretary of State contends by a respondent's notice that they were wrong on the first point. The Court accepted then at 44, Lord Justice Lloyd, with whom the other judges agreed on this point, paragraph 44, I accept Mr. Sales's proposition that the European cases show that in this area the scope of application of the treaty for the purposes of Article 12 includes both cases where a right of residence arises directly under the treaty and those where it arises separately under the law of the member state. It does not extend to cases where no right of residence exists under either the treaty or the relevant domestic law. So that was the crucial holding on Article 12. The claimants were outside the personal scope of Article 12. Now, those claimants did not rely upon Regulation 140871. It may have been because they hadn't worked in the community. It may have been for other reasons, but for whatever reason, the issue wasn't before the court. So the court then concludes at 45 that the right claimed by Ms. Abdirahman and Mr. Ulusow is not within the scope of application of the treaty. On that basis, the need to justify the discrimination on the grounds of nationality which is involved in the use of the right to reside test does not arise. Now, the court did go on to consider it obiter. If I could just take your lordships to that. Sorry. I'm sorry, guys, I've lost my note on it. Paragraph 49 over the page. 48, I'm asked to look at 48.
But you're asking us to look at 49, are you?
I'm being asked to look at 48, and I'll do that first.
Yeah.
Halfway down, if the question were to arise for decision, I would reject that approach. That was the approach that was relied upon to say that it should be a question of consideration on the same basis as the immigration authorities would approach it.
Yes.
It seems to me that it would be disproportionate to insist on individual consideration as a matter of immigration control of each claimant's circumstances in order to decide whether social security benefits should be payable. The observations of the court in Triani's case, cited above at paragraph 32, seem to me to show that the approach adopted by the 2004 regulations is justified, even though it does involve indirect discrimination on the basis of nationality. And then paragraph 49 refers to what had been laid before the Social Security Advisory Committee when the regulations in question were adopted. And at paragraph 50, the judge says that he also agrees with, and this is 4 lines into paragraph 50, 5 lines in, I also agree with them that further support for the same conclusion may be derived from the judgment of Lord Justice Sedley and Morris. The problem in all significant respects is a problem of foreign nationals either coming to this country benefit tourism or outstaying their leave to be here, irregular status, in order to take advantage of the priority housing status according to homeless families. Measures directed at this, I accept, require no explicit justification, whether because they are an aspect of immigration control or because they are an obviously legitimate response to a manifest problem. Now, pausing there, Morris was a case under the European Convention on Human Rights, Article 14, not a case of European Union law. And in my submission, it has no application or read over to the detailed legal scheme that I've been addressing you on today. Lord Justice Mosley had something to say about the legitimate... Moses, I'm so sorry. Had something to say about the... about justification at page 274, paragraph 67. 67, there remains then only one potential source for the creation of a right to reside, namely Article 18 EC. This imposes, as part of our law, an obligation on the UK to confer a right to reside subject to proportionate limitations and conditions proportionately applied and designed to achieve the legitimate aim of protecting the fisc against unreasonable burdens imposed by those who are not economically active. And he describes that objective, expressed in plain terms in the preamble in Article 1 of Directive 93/64, as a corollary to the important principle expressed by Advocate General Heelherd in Triani, that the basic principle of community law is that persons who depend on social assistance will be taken care of in their own member state. Now, what I say about that is, first of all, there isn't any basic principle of community law of that kind, but that secondly, even if there were, it's not an exception under the scheme of the treaty to the prohibition of discrimination in Article 3 of Regulation 1408/71.
Could you just repeat that last bit? Sorry.
It's not an exception to the prohibition on discrimination in Article 3.1 of Regulation 1408/71. And this is the second part of the basis of the Court of Appeal's reasoning, and is central to what is said to be the consideration independent of nationality. This idea that, first of all, there is a basic principle that persons who depend on social assistance will be taken care of in their own member state. And what is said to be a correlative principle. I say said to be because the principle as stated, of course, does not appear to permit the exclusion of entitlement to social assistance. It is intended to impose a burden of the provision of social assistance. Persons who depend on social assistance will be taken care of in their own member state. Now, as we shall see, Advocate General Heelherd doesn't identify any basis in community law or international law for the assertion that member states must provide social assistance to their own citizens. And I don't see in the respondent's case either the assertion that the Secretary of State has an obligation to provide social assistance to all of British citizens who need it, nor the supposed basis in community law for such an assertion. What instead, as we shall see, the respondent contends for is that there's quite different principle, which is that people who are not economically active can be refused social assistance. Now, I can see that that might be connected to the existence of that principle. But the principle that the Secretary of State relies upon is not one which appears anywhere in the text of the treaty, the regulations, recitals to the regulations, or in the case law of the Court of Justice as an exception to the prohibition on discrimination. Can I take your Lordships to Troiani, which is in volume 7 at divider 64. Sorry. Not in volume 7.
No, it can't be.
Is it divider 64? Volume 7 at divider 79.
Mr. Cox.
779.
I'm so sorry. Volume 7 at divider 79.
79.
Yeah.
Yes.
Now, this case is central to the Court of Appeal's reasoning and to the arguments of my learned friend, so I just want to take a little time on it, if I may, and to show you, Lordships, that it wasn't concerned with the issue with which your Lordships are concerned.
Could you just remind us of where it is in the Court of Appeal to see if there's a proposition there you attack?
It was relied upon,
We've
passage that I
29,
cited.
30.
It's relied upon in the conclusion that I cited to your Lordships
52.
at
Certainly
52,
gets its mention in
page
52.
19, and it begins at paragraph 29, which is at page 10.
Yes.
With a citation from Abdirahman.
Yes. Right.
Can I just take your Lordships to the proposition at paragraph 30 in the Court of Appeal's reasoning, just before we leave that? It is important to appreciate that both this court and the Court of Justice have accepted as part of the ratio of their decisions the proposition that to preclude those who are not economically active and not self-sufficient from access to social assistance by depriving them of a right of residence pursues the legitimate aim of protecting the public finances and is proportionate to that aim. We say that's not the ratio of Troiani. That is the ratio of Abdirahman, the Court of Appeal's reading of Troiani. That's not the ratio of Troiani. The Court then goes on to note, of course, in Abdirahman and Kashmarek, the effect of that conclusion was to exclude the alleged discrimination from the scope of the prohibition in Article 12, but it does not necessarily follow that the proposition for which those cases are authority loses its force when considering the justification for discrimination within the scope of 1408/71. I say, oh yes, it does, if the justification is based on nationality, as it clearly is. But then dealing with Troiani, you see the facts. Page 3. Mr. Troiani was a French national who moved to Belgium in 2000 after residing without being registered, I think that means registered with the national immigration authorities, at a campsite in a youth hostel. He was given accommodation in the Salvation Army hostel in Brussels from January 2002, where in return for board and lodging and some pocket money, he did various jobs for about 30 hours a week as part of a personal socio-occupational reintegration programme. As he had no resources, T approached the CPAS with a view to obtaining social assistance, the Minimex. So just pausing there, this concerns the same benefits that was examined in Herx and is not social security under Regulation 1408/71. So Mr. Troiani couldn't rely upon Regulation 1408/71. On appeal, the referring court stayed the proceedings and sought a preliminary ruling from the Court of Justice, asking essentially whether a person in a situation such as that of Mr. Troiani could claim a right of residence as a worker, a self-employed person or provider or recipient of services in the meaning of Articles 39, 43 and 49. It further asked whether, if the first question was answered in the negative, a person in the situation of Mr. Troiani might, simply by virtue of being an EU citizen, enjoy a right of residence in the host member state by the direct application of Article 18 of the treaty. In each case, it sought to know the consequences for an application for social assistance. So we note
he couldn't rely on 1408 because he'd never paid into a pension in Belgium or somewhere. France, I mean.
that might have been true as well, but he couldn't rely on it because the Minimex is outside the material
Minimex
scope.
is outside
It's
it, I
ratio
see.
in materiae.
Yes, it might have been personal scope as well, one doesn't know.
Yeah.
But it clearly was outside the material scope. Yes.
Yes, I see.
And in fact, as we see then, the court didn't refer any question about discrimination. It was only asking about whether or not Mr. Troiani had a right to reside. Now, I'll deal with the court's judgment first before turning to the Advocate General's opinion.
It's an Article 18 point.
The first question is about workers, and we don't need to look at that. The court says he might be.
Yeah.
Which seems quite generous, but there we are. The court looks at the second question under page 843 at paragraph 30. If he's not a worker, might he acquire a right of residence simply by virtue of Article 18? In other words, the general treaty right to move and reside freely within the territory, subject to limitations and conditions laid down in the treaty or by measures adopted to give it effect. We see the court referring to that at paragraph 32. That right is not unconditional, however, it is conferred subject to the limitations and conditions laid down by the treaty and by the measures adopted to give it effect. And it then refers to Directive 93/64, which is, of course, the relevant directive for persons who aren't workers or self-employed at that time. Follows from Article 1 of that directive that member states can require of the nationals of a member state who wish to enjoy the right to reside within their territory that they themselves and the members of their families be covered by sickness insurance in respect of all risks in the host member state and have sufficient resources to avoid becoming a burden on the social assistance system of that state during their period of residence. Now, the court recalls, first of all, that even those limitations and conditions are subject to the overriding requirement of proportionality. And then the court says that it was the lack of resources that led Mr. Troiani to claim the Minimex benefit. And in those circumstances, a citizen of the Union in a situation such as that of the claimant in the main proceedings does not derive from Article 18 the right to reside in the territory of a member state. And it compares it with a different case, Baumbast, which we have in the bundle, but I don't propose to take your lordship to at the moment. Contrary to the circumstances of that case, there is no indication that in a situation such as that at issue in the main proceedings, the failure to recognise that right would go beyond what is necessary to achieve the objective pursued by that directive. In other words, on the particular fact of Mr. Troiani's case, he didn't have a right to reside under Article 18. It wasn't disproportionate to limit his right to reside because he didn't have sufficient resources. There are other cases that we can show the court in which the court has reached a different conclusion on the facts of the case. The court then goes on to note, see in paragraph 37, that in fact Mr. Troiani had been issued with a residence permit and was therefore lawfully resident in Belgium. The court says at 38, it should be recalled here that it is for the court to provide the national court with all those elements of the interpretation of community law which may be of assistance in adjudicating on the case pending before it, whether or not that court has specifically referred to them in its questions, formulation that the court uses in my submission when it wishes to provide further information to the court, but not one which it regards itself as inevitably bound by to offer answers to questions that aren't posed. And the court then determines that Mr. Troiani may rely upon the prohibition in Article 12 on discrimination. And we see that the court first of all says in paragraph 40, in the present case it must be stated that while the member states may make residence of a citizen of the Union who's not economically active conditional on his having sufficient resources, this does not mean that such a person cannot, during his lawful residence in the host member state, benefit from the fundamental principle of equal treatment as laid down in Article 12. Now, pausing there, the reason that I haven't relied upon these passages is because of the Court of Appeals holding in Abdi Rahman that the appellant is, while lawfully present, is not lawfully resident within the meaning of Article 12 of the European Community Treaty. But the court holds that Mr. Troiani was because he had a residence permit. So we see that in the 3 points the court makes. First at 42, a social assistance benefit such as the Minimex falls within the scope of the treaty. There's a reference to the case of Krzelczyk, which is the footnote. Secondly, with regards to such benefits, a citizen of the Union who is not economically active may rely on Article 12 where he has been lawfully resident in the host member state for a certain time, pausing there, whatever that means, or possesses a residence permit. And thirdly, national legislation such as that at issue in the main proceedings, insofar as it does not grant the social assistance benefit to citizens of the European Union, non-nationals of the member state, who resides there lawfully even though they satisfy the conditions required of nationals of that member state, constitutes discrimination on grounds of nationality prohibited by Article 12. The court doesn't even consider whether or not it's justified, in my submission, because it was direct discrimination, because the provisions of the Minimex, as the court explains in 44, did not grant the social assistance benefits to those people, even though they satisfied the conditions required of nationals of that member state. So in my submission, the judgment in Troiani is authority for the proposition that a person in Mr. Troiani's factual situation didn't get a right to reside from Article 18, but that because he held a residence permit, discrimination in respect to the Minimex was prohibited, and that the rule precluding him from entitlement to the Minimex was direct discrimination which was incapable of justification. Before we turn to the Advocate General's opinion, though, it's worth noting what the court says to the member states in paragraph 45. It should be added that it remains open to the host member state to take the view that a national of another member state who has recourse to social assistance no longer fulfills the conditions of his right of residence. In such a case, the host member state may, within the limits imposed by community law, take a measure to remove him. However, recourse to the social assistance system by a citizen of the Union may not automatically entail such a measure. In other words, in my submission, what the court is saying is, so long as the person resides on your territory and falls within the personal scope of a prohibition on discrimination, you may not discriminate. But you may expel if they lack a right to reside under community law. that is the solution if you don't want the person to claim the benefit. Now, my learned friends, in their respondent's case, say that the last proposition is right, that of course a member state may expel a union citizen who no longer has a right to reside in the territory, subject to, we would say, conditions of proportionality and so on. But they say that it's implicit in that one can take the lesser step of starving them out by denying them social assistance benefits necessary, and even by denying social security benefits necessary. But in my submission, it's very significant that the court didn't say that in Troiani, and that in fact the court held that Mr. Troiani was entitled, as a matter of community law, to receive the Minimex. In my submission, the argument that the respondents advance on that point is to confuses two different domains, confuses the prohibition on discrimination with the power to expel. And as we have seen, the power to expel one's own nationals, the power to expel foreign nationals, necessarily implies a discrimination between them and one's own nationals. But that power to expel does not extend to other powers, such as the power to discriminate on grounds of social security. Can I just take your lordships then to the Advocate General's opinion?
You don't happen to know whether our immigration rules in fact provide for the expulsion of EC nationals, EU nationals who fall on hard times, fall on social security?
Yes, we do, I think, know the answer to that. And there are provisions of the immigration regulations in Volume 1 of the authorities. I can take your lordship to those. And in particular, the relevant regulations at the time are at tab 6. And the power to remove is in Regulation 21, which is at page 10. You see in Regulation 21, first of all, circumstances prohibiting admission, and then in paragraphs 1 and 2, prohibition on admission. Paragraph 3, a person may be removed from the United Kingdom, A, if he is not or has ceased to be a qualified person or the family member of a qualified person. And then under B, a discrete provision to remove even where a person is a qualified person on the grounds of public policy, public security or public health. The definition of qualified person is at Regulation 5, which is at page 4.
It's workers.
Lists the categories of persons by reference to their community law labels who would have a right to reside.
Yeah.
So we see 5.1a, worker, self-employed person, provider of services, recipient of services, self-sufficient person, retired person, student or self-employed person who ceased activity.
So this lady is she within this?
She's not advanced the contention that she's a qualified person. No. She's not contended that she had a right to reside at the material times.
She doesn't seem to fall within any of the heads listed.
So she would, on that basis, she would be a person to whom Regulation 21.3a 1 would in principle apply.
Yes, I mean public policy doesn't deal with this sort of economic aspect at all.
No, and it's not necessary because 3b only deals with a person who's a qualified person. So 3a is
Right.
the relevant provision, and it deals with the European Union citizens who have ceased to hold an enforceable community right to reside. Now that decision hasn't been taken. That's a decision for the Secretary of State for the Home Department. Despite the length of these proceedings, Secretary of State for Work and Pensions hasn't invited him to take one. If he did take such a decision, there would be a right of appeal to what is now the first tier tribunal.
I mean, I don't understand what's meant by a retired person there.
Well, retired person is defined in, I think, Regulation 3.
It's no good if you're retired in Latvia.
No, unfortunately not. So Regulation 3, but looking over the page at page 3, definition at F, retired person means a person who has pursued an activity as an employed or self-employed person, and that, by construction from the directive, means in the United Kingdom, and is in receipt of an invalidity or early retirement pension, etc., sufficient to avoid his becoming a burden on the social security system, it says there, of the United Kingdom. So we would submit that that needs to be read in the light of the community legislation as well, and is covered by sickness insurance in respect of all risks in the United Kingdom. Now, this was the measure that was in force when the decision on benefits was taken. These regulations have now been replaced by the 2006 regulations, and while those different definitions have been recast, the same principle applies. A person who ceases or does not have a right to reside under EU law may be removed from the United Kingdom pursuant to a decision of the Secretary of State of the Home Department. Of course, that decision would be one taken on all of the individual facts of the appellant and would give rise to
Well, our last 8 of the Convention will all come into play and all the rest of it.
Yes, and proportionality under EU law, we would say. But none of those issues have arisen, because what the Secretary of State says is that he is entitled, by virtue of the principle that he derives from the Advocate General's opinion, to impose a blanket prohibition on entitlement to state pension credit for persons who do not have an enforceable right to reside.
Can we just ask, it's not relevant to the legal argument, but how is your client keeping body and soul together at the moment?
Well, because the appellant succeeded in her appeal at first instance, she was paid state pension credit by the Secretary of State, and that payment continued down to the date of the Court of Appeal's decision. And the appellant was very thrifty, and the appellant saved some of her state pension credit, and she has been living on her savings from state pension credit and her Latvian pension that she's continued to receive throughout to date. Her savings have diminished since the Court of Appeal's judgment was given, and they are getting quite small now, and it may be that an application to the Secretary of State for interim payments will need to be made again shortly, but she still has some savings left.
Now, how are we getting on through your written case?
I just wanted to take your lordships to the Advocate General's opinion in Triani,
Yes.
since that is the basis for the Secretary of State's argument about the principle.
And we're told that the court adopted what the Advocate General said.
Well, you've seen what the court said.
Yes.
It'll be for your lordships to decide whether or not that was an adoption of what Advocate General
Yes.
Heelherd said. The crucial paragraph is paragraph 70 at 837.
Is this page 837?
837 at paragraph 70.
Yeah.
The Advocate General said, "It is clear that Mr Troiani cannot provide for himself, since he is applying for social assistance in Belgium. Denial of the right of residence is not disproportionate, since the limitations and conditions for which Directive 93/64 provides are intended to cover precisely persons such as Mr Troiani, who, for at least a substantial part of their income, depend on social assistance in the host member state." Well, thus far, my submission, the court would agree with that, because the court goes on to hold that Mr Troiani was indeed not entitled to a right of residence under that directive. The last sentence, though, it doesn't find in my submission any echo in the court's judgment. The basic principle of community law is that persons who depend on social assistance will be taken care of in their own member state. And in fact, of course, the results that the court reached was a different one to that the Advocate General proposed, because the Advocate General rejected the idea that the discrimination argument could assist the appellant. We get that in paragraph 71 onwards, and in particular at 74. Sorry, if your lordships actually would just read from halfway down 73, just below the words Grzelczyk. If a residence permit is issued purely on the basis of national law, as is the case of Mr Troiani, there remains the possibility of prohibited discrimination on grounds of nationality. This might well have been the case if Mr Troiani had been granted indefinite leave to stay. His residence status would then have been comparable to that of a Belgian subject, and the refusal to grant an allowance would have been a consequence not of a difference in residence status, but of a difference in nationality. However, in the present case, no such permit was issued. If, on the other hand, as according to the file happened in this particular case, a temporary residence permit is issued, and in the words of the Cabot 2 judgment, the union citizen concerned does not have an unconditional right of residence, that citizen cannot claim social assistance from the member state even on the basis of the non-discrimination principle. His right of residence is not comparable in all respects to that enjoyed by a person who is present and settled in the Kingdom of Belgium. Now, clearly that part of his reasoning was rejected by the court. The court certainly does not adopt the sentence, the basic principle of community law is the persons who depend on social assistance will be taken care of in their own member state. And it's surprising that such a basic principle should find no statement in any of the other opinions of Advocate Generals or of the court, let alone the treaty. Even if that were the principle, it doesn't follow that there's a correlative principle that a union citizen may be denied social assistance by the state of residence. It might be that Latvia is required to provide Ms. Patmalniece with social assistance on her arrival back in Latvia if she went here. Though, of course, one would note that if a British citizen came here from Latvia, they wouldn't be entitled to state pension credit on their arrival here because they wouldn't be habitually resident. So the Secretary of State isn't living by this principle, certainly true. But it doesn't follow anyway that the correlative principle of denial exists.
So you're challenging the first sentence of paragraph 30 in the Court of Appeal, then, as not supported, at least by anything that the court itself has said. This is at page,
Yes.
page 10.
Yes. And indeed, if it were possible to justify direct discrimination on the basis of considerations of excluding the non-economically active foreigners from your benefit system, why wasn't that accepted in Trojani? He was a non-economically active foreigner. Why does it matter that he had a residence permit? If the basic principle is one can exclude non-economically active foreigners from your residence, from your benefit system, why does it matter that he was given a residence permit? My submission, the answer is because the court didn't accept any such general principle about discrimination, because the court turned its face against the possibility of any discrimination. So in my submission, Trojani does not support the Secretary of State's contention that there is a principle of EU law, nor does it require, nor does it permit to be read over in the way that the Court of Appeal found, to cut down the effect of Article 3 and limit it as regards persons who don't have a right to reside.
Well, I was trying to trace where you are in your written case.
Yes.
Is it possible to do that?
Yes, my Lord, I just wanted to make the last submission that I wanted to make before I reach the Irish point, which is the last point, is whether or not state pension credit is part of the social assistance system of the United Kingdom. Now, I only need to deal with that argument if your lordships are against me on the argument that I've just been putting. Because if there is a principle that the Secretary of State may exclude from entitlement on nationality grounds to social assistance, then it must follow that that principle can only apply to social assistance. Now, the Court of Appeal found that even though state pension credit was a benefit under Regulation 140871, that it was also social assistance under the residence directives. I just want to take your lordships to see where the phrase social assistance comes from in the residence directives. In volume 1, Act divided 24, find Directive 9364, which was the material provision community law during the period in question. Now, this directive, while it's headed on the right of residence, is complementary to other community law provisions dealing with the right of residence of workers and self-employed persons. And this directive deals with the residual category. And we can see that the recitals refer the fifth recital, whereas Article 3C of the treaty provides that the activities of the community shall include, as provided in the treaty, the abolitionist between member states of obstacles to the freedom of movement for persons. And then there's a reference to Article 8A, which has become Article 18. And then the penultimate recital on that side of the page, whereas beneficiaries of the right of residence must not become an unreasonable burden on the public finances of the host member state. And then that is expressed in terms of the rule in Article 1, in the next column, a third of the way down. Member states shall grant the right of residence to nationals of member states who do not enjoy this right under other provisions of community law, and to members of their families as defined in paragraph 2, provided that they themselves and the members of their families are covered by sickness insurance in respect of all risks in the host member state, and have sufficient resources to avoid becoming a burden on the social assistance system of the host member state during their period of residence. Now, we say that that language deliberately echoes that of Article 4.4 of Regulation 1408/71, and the settled distinction between benefits that fall outside that regulation as being social assistance and benefits that fall within it as being social security. Now, before I just expand on that submission, I just want to address you as to what we say the rationale for it is.
Sorry, I'd like to be reminded of Article 4.4.
Yes, sir.
Exactly, it says.
Of course, Article Regulation 1408/71
Yeah.
is at tab 16.
Yes, I see. Yes, thank you.
The reference to social and medical assistance. Well, we say the rationale for that distinction is that benefits that fall under 1408/71 are benefits which the claimant has a right to receive, or which the claimant may have a right to receive as a matter of community law, and that they therefore properly count as part of the resources of a European Union citizen residing in the territory of the member state concerned. So just to take an extreme case, let us suppose, or a slightly different case, let us suppose that the appellant's Latvian pension were far more than she needed to live off. That Latvian pension would, of course, be social security. Now, in my submission, social assistance is being used in contradistinction to the term social security, because there would be no rationale for denying the appellant the right to live here on her Latvian pension. Let us suppose that the social security were paid to her by the United Kingdom based upon her earnings here. Again, there would be no rationale for her social security benefits not to count as her own resources. And in my submission, when the community legislator adopted the phrase social assistance, it was intending to give it the narrow meaning of those benefits that fall outside the scope of 1408/71 because they're social assistance. My submission is significant that the legislator chose that term and did not use the phrase characteristics of social assistance, which is the language that is currently used in Regulation 1408/71, but had been in the court's case law since 1972.
Sorry, what's the corresponding phrase?
Well, the phrase in the directive is social assistance system. The phrase in the regulation at 2A, page 9, is special non-contributory cash benefits which have characteristics both of the social security legislation and of social assistance.
I haven't picked that up, I'm afraid. This is
I'm so sorry.
2A, yes.
2A,
I've got it, yes.
428, yes, at the top of page 9 of
Yes.
Regulation 1408/71.
Yes, yes.
Now, that phrase appears in the legislation after the 2005 amendment But that phrase goes back to the earliest case law on the regulation. In the case of Frilly. Perhaps if I could just take your lordships to that.
We tried to keep you away from it earlier
Well,
on.
what I wanted to show you, lordships, is that it had been there for 20 years, and therefore it would be surprising that the legislator was not using the term social assistance in the same way that it had been used for the last 20 years.
Yes, well, you're very persistent. It's volume
Judgment
5,
in Frilly is in
60, isn't it?
I'll wait for your second serve. Which tab is it?
It's tab,
60.
it's tab 60 in volume 5. Now, this benefit appears to have been materially identical to state pension credit, which is another just oddity of the case. And we see that from the judgment, which begins at page 406. But I just first of all need to show you, Lordship, what the law that was under consideration. We can see from paragraph 1 of the judgment, 406, that the Brussels Labour Court had put various questions concerning the interpretation of Regulation 1612 of 68 and of Council Regulation 3 of the 3rd of December 1958. Council Regulation 3 is the predecessor to Regulation 1408/71, so called because it was the third regulation that the Council made. But the provisions in question are materially identical. They referred to social security benefits, and what was excluded was social assistance benefits. And if your lordships want to look at it, then Regulation 3, at least in the French text, but with the translation of the material provisions into English, is at tab 13. But I don't propose to take your lordships to it at the moment. I think I can get enough from this judgment.
Yes.
See the facts at paragraph, or the relevant considerations from paragraph 5. The request for an interpretation made by the Labour Court concerns a question which has arisen over an act aimed at guaranteeing a minimum income for needy men and women at least 65 and 60 years old respectively. So there's one distinction. This benefit is granted to Belgian nationals on the sole condition that they reside on national territory. An alien, however, is not entitled to the benefit under this law except on meeting two conditions: to be a national of a country with which Belgium has concluded in the matter an agreement of reciprocity, and to have resided in Belgium for a period of 5 years preceding the date on which they qualify for this guaranteed income. The plaintiff in the main action, an Italian national who's in receipt of a retirement pension in Belgium in her capacity as an employee, by reason of having been employed for a short time, fulfilled, subject to verification which the Labour Court intends to carry out, the conditions required by the Act, except that of reciprocity, as Belgium and Italy have not concluded any agreement in this matter. So she met all of the requirements for the benefit, except the condition that only foreign nationals needed to meet, namely of reciprocity with their own member state. And then over the page at paragraph 11, under Article 1b, Regulation 3 is applicable to the whole body of legislation in member states which deals with social security schemes and branches of social security. So on your lordship see there the same language as is now in Article 4 of 1408/71. On the other hand, under paragraph 3 of the same article, the regulation does not apply to social and medical assistance. And then, although it may appear desirable from the point of view of the application of the regulation to draw a clear distinction between legislation concerning social security on the one hand and assistance on the other, the possibility cannot be excluded that some laws may fall within both of these categories because of their scope in relation to individual cases, of their objectives and of their methods of implementation, and thus escape any overall classification. In some of its features, legislation on a guaranteed income is akin to social assistance, especially when need is the essential criterion in its implementation, and there are no conditions as to periods of employment, of affiliation and contributions. But it's nevertheless close to social security in that, by not considering each case on its merits, it gives all beneficiaries a legally defined position, giving them the right of a benefit similar to old age pensions mentioned in Article 2 of Regulation 3. In view of the wide definition of the people entitled to benefits, such a legislation fulfills in fact a double function, which is on the one hand to guarantee a minimum income to persons who are entirely outside the social security system, and on the other hand, to provide supplementary means to persons whose social security benefits are insufficient. And what we see there in my submission is a distinction between persons outside the scope of the regulation and inside the scope of the regulation. Under Article 2(1)(c), Regulation 3 applies to all old age benefits. Under Article 1(s) of the same regulation, the term benefit should be understood in its widest meaning as covering all pensions and allowances. And then we see in paragraph 19, with a page, thus vis-à-vis an employee or a person assimilated thereto who has performed periods of work in a member state, permanently resides there and is entitled to a pension, the legislative provision conferring on all elderly inhabitants a right to a legally protected minimum pension falls, so far as these workers are concerned, within the field of social security, mentioned in Article 51 of the treaty, and other regulations made in pursuance thereof, even if such legislation might fall outside this field so far as concerns another category of beneficiaries. In other words, the persons who meet the personal scope requirements of the coordination regulation, the benefit counts as social security, but to those who fall outside, it does not count as social security. 19. The absence of any agreement or reciprocity may not therefore be validly raised against such a worker here being used in the wider Article 42 sense, such condition being incompatible with the rule of equality of treatment, which is one of the fundamental principles of community law embodied in this matter in Article 8 of Regulation 3, which is now Article 3 of Regulation 1408/71. So that is the first case in which the court was asked to consider what has later been called a hybrid benefit or a dual characteristics benefit, and what subsequently became subject to the discrete coordination system established by Article 4(2)(a). And I've traced what I've done in the printed case, and I don't propose to take the Lordships to it, but what I've done in the printed case from paragraph 38 onwards is to trace the development of that, or to trace the repetition, rather, of those principles, and there's consolidation in the language of characteristic of social assistance and characteristic of social security.
Yes.
Now, in my submission, if we just turn to the wording of, back to the wording of Regulation 1408/71, social assistance, properly so called, must fall outside the scope of Article 4, and therefore outside of the scope of the regulation. That's because of the language of Article 4(4). And in fact, the Council has no power to provide for the coordination of social assistance, properly so called, because the article is because the enabling provision is addressed only to social security. So while the Council has power to deal with social security benefits, which have characteristics of social assistance, it does not have power to deal with social assistance benefits, properly so called. That's against that background of set out in the printed case of 20 years of case law, that in my submission, 20 years of case law as at the date of the directive, 40 years now, that the legislator must be taken to have been referring to social assistance of the kind excluded from the scope of Regulation 1408/71 and the systems of benefits provided as social assistance.
Sorry, why, I'm being very obtuse, why is ours a hybrid?
State pension credit is a hybrid because it provides a minimum income to people regardless of periods of contributions or residence. And so, applying the case law of Frilly, that is a characteristic of social assistance.
So why isn't it I go back to your paragraph 37, which tells us what social security is.
Yes?
You say it falls within that.
Yes? I say it is social security. But I accept that it has characteristics of social assistance.
What are they?
That it is paid entirely on the grounds of needs and without reference to periods of contributions or periods of residence.
So it says it's a minimum income is provided regardless of the amount of
without
contribution.
regard to periods of contributions, national insurance contributions,
Yeah.
or of residence. And in that sense, it's different from what might be called classic social security benefits, such as unemployment benefit, which are paid because of a contributions record. So what the court has said in Frilly is that a benefit which is means tested has a characteristic of social assistance, but if it has the characteristics of paragraph 37 of the case, it is social security.
Let's see if I can grasp that. I mean, if you look at some of the others in Article 4.1, let's take death grants, for example. There's no means testing in the case of a death grant, is there?
Well, there is actually.
Is there?
Yes.
I'm so sorry.
Under the social fund,
A bad example.
it's quite very harshly means tested. In fact, the social fund provision. But I'm sorry.
Two limbs, one contributory, one non-contributory.
Yes, but I'm reminded that there is a contributory death grant, which I'd forgotten about. I'm sorry.
Yes.
Bereavement benefit, yes, and bereavement benefit
yes.
is not means tested.
Yes.
So the contributory benefit is not means tested. The non-contributory benefit is means tested.
Anything means tested is hybrid, is it? Well, as long as, of course, it gets
No.
into the social.
Well, it depends.
Is it not, I'm sure you'll tell me I'm wrong, this particular sort of means testing is
Yes.
done in an entirely objective way, and either you meet it or not.
Yes.
Whereas if it is a grant out of another social fund in order to allow someone to buy a refrigerator or something of that, that involves individual judgment of the particular case.
Yes.
Is that right?
Yes. The latter is pure social assistance.
Yes.
Because it is because not only means tested, but based on a discretionary individualised assessment. The former has characteristics of social assistance, namely the means test, but is nevertheless a social security benefit under Article 4. The definition of...
And also, sorry, just to state the obvious, it's linked to old age, whereas the refrigerator might be for anyone
Yes,
of any age.
no, Your Lordship is absolutely right, that it must also meet the requirement it is linked to one or more, but not all of, as it were, not an umbrella benefit, must be linked to one of the risks under Article 4.1. The definition of what the regulation classifies as benefits which might be labelled hybrid is, or for the material time, is set out in the text at 2A. So there are benefits that have characteristics of social assistance, but because they are not listed in the annex, they are not hybrid benefits, or at least they are not covered by the scheme for hybrid benefits. The essential feature of the distinction that Regulation 1408/71 makes between these two different benefits is that special non-contributory cash benefits, that is the benefits under paragraph 2A, are not exportable. And we see that from Article 10A, which is over the page, so page 11. So if we see first of all the general rule in Article 10,
Exclusively in the territory.
yes, Article 10A has the term exclusively in the territory of the member state, whereas Article 10 precludes reduction, modification, suspension, withdrawal or confiscation by reason of the fact that the recipient resides in the territory of a member state other than that in which the institution responsible for payment is situated. So the essential function of the distinction under 1408/71 is that special non-contributory benefits may not be, in the language of the cases or in the language of those who write about them, exported.
May not be or need not be.
There is no entitlement under community law to export.
Yeah. Be more generous if you want.
Yes. And in fact, state pension credit rules provide for continued entitlement during temporary absences abroad. And so, while a child benefit may be exported, that is not a special non-contributory cash benefit, and a retirement pension that is contributory may be exported, income support or state pension credit may not be. That's the function of the distinction made in the regulation. And in my submission, that's the only function of the distinction made in the regulation. It isn't a function of this distinction to say that there's a different test for discrimination for special non-contributory cash benefits. It isn't a function of the regulation to say that special non-contributory cash benefits form part of the social assistance system for the purpose of a residence directive. And in my submission, the Court of Appeal was wrong to suggest the contrary or to hold the contrary.
So Article 10 is the only one that deals with this.
Article 10A.
10A.
Yes, Article 10A is the article that sets out the special provision for special non-contributory benefits, yes. They're not otherwise subject to any special distinction. So there is no exception in Article 10A to Article 3, and there is no exception in Article 3 for benefits falling under Article 10A. And there is no dispute under Article 10A1 that the claimant is in the territory of the member state, that she resides in the territory of the member state, and that she would receive it under the legislation of the member state. I just mentioned to your lordships, just to elaborate, just to make my last point on that submission, to show your lordships the amendment that originally inserted these provisions, which is at tab 19. And this is the opening, this is the text of Regulation 1247/92. Your lordships will appreciate Regulation 1408/71 has been amended on lots of occasions, and this is one of the many amendments. But this is the amendment that, first of all, drew the distinction in the legislation between special non-contributory cash benefits and other benefits. And we see the relevant recital. It's in the second column, 4 paragraphs down. Well, in fact, no, I perhaps ought to take your lordship to the left-hand column, or the last recital, I'm sorry. Whereas it is also necessary to take account of the case law of the Court of Justice, stating that certain benefits provided under national laws may fall simultaneously within the categories of both social security and social assistance, because of the class of persons to whom such law apply, their objectives and their manner of application. Now, pausing there, that's not the language that the Court has adopted, but the gist is, in my submission, the same. That is, there are social security benefits which have characteristics of social assistance. See, whereas the Court of Justice has stated that in some of its features, legislation under which such benefits are granted is akin to social assistance in that need is an essential criterion in its implementation, and the conditions of entitlement are not based upon the aggregation of periods of employment or contributions, whilst in other features it is close to social security to the extent there's an absence of discretion in the manner in which such benefits as are provided thereunder are awarded, and that it confers a legally defined position on beneficiaries. Whereas Regulation 1408/71 excludes from its scope, by virtue of Article 4.4 thereof, social assistance schemes. In my submission, that's exactly the same language used in the Residence Directive. Whereas the coordinations referred to in their methods of application are such that a system of coordination which differs from that currently provided for in Regulation 1408/71, and which takes account of the special characteristics of the benefits concerned, should be included in that regulation in order to protect the interests of migrant workers in accordance with provisions of Article 51. And then, whereas such benefits should be granted in respect of persons falling within the scope of Regulation 1408/71, solely in accordance with the legislation of the country of residence of the person concerned or of the members of his or her family, with such aggregation of periods of residence completed in any other member state as is necessary, and without discrimination on grounds of nationality. And if one looks over, one sees that the amendment that had effected, and it's been changed a little since, is that we see in Article 1, paragraph 2, inserted the new paragraph 2A. It had been further amended by the time of the period under consideration. But we see that, in essence, that it provides a similar test.
Yes.
And we see that that is when Article 10A was inserted.
Yes. And then we've got the annex.
The annex at that time didn't include state pension credit, because state pension credit didn't exist. But we do see the annex on page 5 at L. We see the benefits that the United Kingdom then listed as special non-contributory benefits.
Well, income support.
Income support, yes.
Basically, income support then got...
Split it up into various different parts, yes. So state pension credit is one offshoot, employment support allowance is another. So that is the, in my submission, the genesis of the special class of special non-contributory cash benefits, and it negatives the submission that they are social assistance benefits in the meaning of the residence directives. My Lord, those are my submissions on the discrimination in respect of UK citizens.
Yes.
If your lordships are with me that the discrimination is direct and that direct discrimination cannot be justified, then we succeed. And if your lordships are with me that the discrimination are with the Secretary of State that it is indirect, but with me that the only justification advanced is not independent of considerations of nationality, then in my submission your lordships will also allow the appeal. However, if your lordships consider that it is possible that that may justify the discrimination, then in my submission your lordships do need to consider the situation of Irish citizens. My submissions on that are set out in the printed case at page 32 onwards, paragraph 149. If I could just take your lordships there. Now, this arises because, and I've set out the text in paragraph 149 of the printed case, the regulation treats a right to reside in the Republic of Ireland in the same way as a right to reside in the United Kingdom. And because just as British citizens all have the right to reside by virtue of nationality in the UK, so Irish citizens have the right to reside by virtue of their nationality in Ireland. It's not a point about the rights of Irish citizens in the United Kingdom. It's because the legislation treats those rights as equivalent. So that means that alone of European Union citizens other than our own citizens, Irish citizens are unaffected by this test. So just as I suggested earlier, if we discovered that Miss Patmalniece's father was a British seaman, she would qualify automatically. Just so if we discovered that her father was an Irish seaman, she would qualify simply because she holds Irish citizenship, even though she has no more connection with the United Kingdom than she had on the facts as understood the day before. Now, we say that that has two effects on the case. The first is that we are entitled to, that the appellant is entitled to be treated equally with Irish citizens. We say that Article 3.1 precludes discrimination between citizens of one member state and those of another. We also say that it undermines the Secretary of State's justification that he is trying to protect the British public funds from depredations by non-British EU citizens, because what he's doing is expressly accepting Irish citizens. We say that that is contradictory to his justification. Now, the first point that I need to deal with is whether or not this argument is open to me in the light of the protocol on the common travel area.
Yes.
And that was the basis upon which the Court of Appeal rejected it.
And this is on movement.
Yes, and I should emphasise that one argument appears to have gone, which is that in both the Commissioners and the Court of Appeal, the Secretary of State argued that European Union law exempted generally what Secretary of State called favoured country or favoured national discrimination. So the Secretary of State advanced, both in the Commissioners and below, that European Union law allowed member states to favour nationals of other member states and that didn't prohibit that at all. And in fact, in his skeleton argument below, gave the example of Swedish and Danish nationals. And that was accepted by the Commissioner, but the Court of Appeal didn't reach it. In my submission, it has no basis at all in European Union law, and there never has been any material to suggest that Swedish and Danish nationals get special treatment in their own countries. And since it isn't pursued in the respondent's case, I don't propose to address it. But turning to the protocol on the common travel area, which is in volume 1 of the authorities, at tab 11. Now, this protocol has never been considered by the Court of Justice. And only friend mentions two cases where he says it was mentioned, but he can take you, your lordships, to them and show you why that supports the idea that it's been considered. But certainly never any question referred on the protocol, nor answered, nor any reference made to it in the substance of any judgment of the Court of Justice. The protocol refers in the recitals to the existence for many years of special travel arrangements between the United Kingdom and Ireland. And Article 1 provides that the United Kingdom and Ireland, provides first of all that the United Kingdom may exercise at its frontiers with other member states, so that's 5 lines down, such controls on persons seeking to enter the United Kingdom as it may consider necessary for the purpose of verifying their right to enter, and in the next paragraph of determining whether or not to grant other persons permission to enter. And then nothing in Article 14 of the Treaty establishing the European Community or in any other provision of that treaty or of the Treaty on European Union, or in any measure adopted under them, shall prejudice the right of the United Kingdom to adopt or exercise any such controls. And then lastly, reference to the United Kingdom in this article should include territories for whose external relations the United Kingdom is responsible. It clearly relates to the Isle of Man and the Channel Islands. Then Article 2, this is the crucial article for our purposes, the United Kingdom and Ireland may continue to make arrangements between themselves relating to the movement of persons between their territories, and then the words, the common travel area, while fully respecting the rights of persons referred to in Article 1, first paragraph, point A of this protocol, that was persons who have the right to enter. Accordingly, as long as they maintain such arrangements, the provisions of Article 1 of this protocol shall apply to Ireland under the same terms and conditions as for the United Kingdom. Nothing in Article 14 of the treaty, any other provision of the treaty, or in any measure adopted under them shall affect any such arrangements. Now I say, first of all, that the Regulation 2.2 is not part of the common travel area. It's not an arrangement relating to the movement of persons between the two territories.
What isn't, sorry?
Regulation 2.2 of the state pension credit regulation, so the provision that's relied upon. So the Secretary of State says, and the Court of Appeal accepted, that discrimination arising from Regulation 2.2 fell within Article 2. I say it's not part of the common travel area because it's not an arrangement relating to the movement of persons. Secondly, it's not an arrangement between the United Kingdom and Ireland because there's no reciprocality. And thirdly, that anyway, Article 3.1 of the regulation does not affect, in the last line of Article 2, does not affect the common travel area. In other words, by granting the appellant the relief that she seeks, that does not affect the operation of the common travel area.
Let me just see how that works in Article 2. Yes, nothing in Article 14 of the treaty shall affect any such arrangement. Can you just say again how that
And my understanding of the way that the respondent puts his case is it's to rely on the words or in any measure adopted under them,
yes,
as a measure adopted under another provision of the treaty. So my understanding is that what the Secretary of State says is that nothing in Article 3.1 of Regulation 1408/71 shall affect the common travel area, which includes Regulation 2.2 of the state pension credit regulations. And I say Regulation 2.2 isn't part of the common travel area, and anyway, the holding that we seek wouldn't affect the operation of that regulation.
well, does that complete the points on the protocol?
No, I just want to if I may,
It's just
expand
one
on
short
those.
point, we might as well take it before we finish.
No, I'm afraid I would want to make good those submissions, and probably for about 20 minutes.
I
think.
see.
And I also need to deal with the
Yes.
contention that it can be severed.
Yes, but we're making good progress, are we?
I think, yes, at most another half an hour.
Good. Well, tomorrow morning at 10:30.
Very good.